So welcome to our April installment of the Entrepreneurship Center lecture series, and welcome to those of you who are joining us online and watching this after the fact. I'm happy to introduce Massimiliano Pastore, qualified lawyer both in Italy and the Czech Republic, so he can give us some general legal advice as well as specifics to the Czech Republic, which I know there are several.
Thank you.
Yes.
Yes, there are. Thank you, Aaron Johnson, for giving me the opportunity to hold this short seminar. But preparing the slides, I was basically looking at my old cases. I've been working as a lawyer here for the past 8 years. Before that, I trained in Italy. I spent basically these 8 years trying to make Italians understand Czech law, and especially when foreigners come to foreign investors come to a new country. There's a row or a set of mistakes they typically make, and it will surprise you. Some of these mistakes were made even by large corporations. So yes, the seminar is designed for young entrepreneurs, but on the other hand, the legal issues we will explore later. They are issues for all the businesses, and they are not pertinent to the Czech Republic only, but I will say to the law in general. I make no ambition to know all the jurisdictions in the world, but I'm familiar with 2 European jurisdictions. I have a deep academic interest for English law. I'm crazy about comparing legal systems and finding similarities, and seeing where's the weird side, where's the normal side, finding arguments. I love seeing how arguments in the American system will work or not work in the Czech jurisdiction and vice versa. So when I look at all this old material I had, I framed these 3 titles. Friends as business partners. This proved to be a problem in a couple of cases I had. The friendship broke early or the business went down. So that's the first topic. Failing to incorporate. This I will explain a bit later. And the third problem is getting locked in a lease. I think these 3 topics relate to the material which was shown before while advertising the seminar, and they are specific mistakes made by entrepreneurs and businessmen, especially when you set up a business and you have a good friend involved in. This is the typical move many people go for, many young entrepreneurs. We go 50-50. He's my brother, he's like my brother, he's my brother. I love him, this is going to work. And believe me, this is not just about green entrepreneurs. I've known a client for over 12 years, he's now 50, and I keep telling him, Sergio, you're doing a mistake here. You can't run 50-50. And he keeps saying, I'm an expert of 50-50 partnerships. He tries to be the facilitator in all these formal partnerships. Well, why are 50-50 partnerships or shareholdings wrong? Well, it may look easy because, if you have some background in company law, you will sooner or later run into a deadlock, meaning that if you have equal voting powers, virtually all resolutions could stay blocked forever. Hello. But even if you have equal management powers, the problem is, I will say, duplicated, because the board cannot take decisions. In one situation I faced, the director belonged to shareholder, was nominated by shareholder A, and my client was shareholder B. And he could not remove the director. basically was left as a form of oppressed minority shareholder with no possibility to remove the director. We looked at the articles of association, the company constitution, and we looked at that Czech law. I even looked at Italian law to see if something could help my client. Nothing. The only solution was to sell the shares. So what was a successful partnership for 12 years became a total train wreck in a couple of years, and nothing could basically help my client if not a sale of shares. It was a total disaster, and we lawyers were looking at each other and said, how is this possible? How is it possible we cannot help this client? There's nothing in the law. There's nothing in the articles. Then you can run into disputes concerning I remember specifically one issue was about where the company seat, the company address is going to be located. And once again, we had a 50-50 SRO in this case, it was a limited liability company. And there was no way we could agree on a new registered address for the company. That address was meaningful for a number of reasons. Under Czech law, by default, the general meetings are held at the registered address of the company. Everything depends also on board, on shareholders' resolutions in a way, dividends. Who declares the dividends? The board. But it's usually the shareholders who, through a resolution, make these dividends available for distribution. And once again, if you have a 50-50 partnership, it could mean that no dividends would be paid for 5, 10, 12 years because of, again, a deadlock either at the board level or at the general meeting level. Do you have experience with the being shareholders already, or have you already? Oh, good. So we can prevent this. Yes, the one possible solution to this problem is obviously to have 51-50, but there are more refined solutions I will show you later. Failing to cooperate is another typical mistake made by, I would say, it doesn't again depend on age. It's based on these arguments. The client has a beautiful project. He sets up a business plan. He researches the market. Everything is set up from the business point of view. He starts assessing the costs. How much is a company going to cost me? 1,000 euros? No, that's too much. No. And then he asks another lawyer, oh, I can offer 500, that's still too much. You know what? I start slow and quiet. I run it on my name. I will, in the Czech jurisdiction, you become legally speaking, an entrepreneur. Like you get a trading name, it's usually your surname, and you're even, in some cases, you're required to make some filings. And yes, you start slow, and it's much cheaper. It's much cheaper because you don't have to deal with the formalities of setting up a company. You don't have to hire a notary or a lawyer. You don't have to run a shareholders meeting every year. It is much cheaper. However, there is a big problem behind this, which is unlimited personal liability for all your debts. I've found myself in the shoes of, I really don't like telling my clients, I told you so. But it happened to me once. An Italian guy came to me with an interesting project about education. I remember I looked at his business project, it was just perfect. It looked to me very persuasive. well thought, based on data. He did a lot of research, but I told him, well, that's great, but you better set up a company to do this. Why? Oh, just because of this problem, the personal liability problem. What could happen to me? Ah, well, what could happen to you? Well, if your business goes bankrupt, it's your personal bankrupt you are talking about. I see. Okay. What else? He kept asking me. Well, you could be sued personally. Like, you will be making contracts with your suppliers, entering into contracts with your suppliers, with your clients, and these clients can sue you personally. Wow, this is not going to happen. It's not going to happen. 3 years later, he came back to me. He was being sued by one of his clients. And of course, it concerned his personal assets. So he wanted to hire me to find a way to get those assets out of court reach. And again, I was in that position where I had to tell my client, well, I told you so. I actually had the temptation to say, you better hire another lawyer now, because I don't want to help you with that. I tried to help him anyway. Also, failing to incorporate means that everything will be on your name, on your trading name, and if you die, or if you become incapacitated from a legal point of view, the business stops. The debts will be transferred by operation of law to your successors. It will become part of your estate. While a corporation puts a clear line, a limited liability company, puts a clear line between your personal assets and the company assets. Sole proprietorship is a very popular form of doing business in the Czech Republic. There are much less constraints when we talk about the filings requirements and also about the accountancy. This is another reason why clients, especially young entrepreneurs, love the sole proprietorship. The accounts they need to keep are much more simplified than the accounts of a company. So again, the accounting and the legal costs are much lower. If you have a specific question about this form of doing business and advantages or disadvantages of that, personal experience to share, just feel free to raise your hand. If you incorporate early, you are also, you will be able to, for example, yes, you can run a trademark, you can register a trademark on your own name, that's true. On the other hand, you could have the trademark registered on the company, so that the company holds all the rights to that trademark, and it's the company which will be licensing the rights in the future. What else? A non-disclosure agreement. The liability under the non-disclosure agreement. Would you like those liabilities to be on your name, on your personal assets, on a limited liability company? I'm not advocating early incorporation at any cost. For small projects in the beginning, it makes sense to start with the sole proprietorship. However, the moment the business expands and the number of potential liabilities arise, moving to an incorporation is a wise thing. Remember that if you incorporate, you will also obtain a higher credibility. I will say, if you fail to incorporate, you may run into a problem of lacking some business credibility. As a person trading under a business name is much different from a company, especially when you talk to banks, to investors. Typically, investors want due diligence companies, not sole proprietorships. They want to check the company accounts, not your personal accounts. If you go for the sole proprietorship, there is no separation between the corporate income and your personal income. So your tax declaration is basically also your business declaration, your business income declaration. This is another third problem which has been, I've seen again, not just fresh entrepreneurs, but also large companies doing the mistake, signing leases containing this language. Well, this is how a Czech lawyer will draft it. This is a lease entered or enter into or concluded for a determined period of time. I do remember the moments the client was enthusiastic. We're gonna sign this store. I need a contract by tomorrow, by yesterday. I say, let's reflect on this. No rush decision. This is a lease for determined period. Oh, what does it mean? It means this. You cannot terminate early, even if the store turns out to be not profitable at all. Oh, really? No, we're gonna find a way later. We will solve this problem later on the way. It's not possible. The law is going to change. I remember all the answers I got on the phone with my client were like, yes, well, if that problem arises, we will find a solution. One client went into denial mode. I remember that. He told me, this is not possible. Like, what do you mean it's not possible? It can't be possible that the law dictates a fixed term and you cannot break the lease early. Well, that's the law how it stands. And we're talking about different time horizons here. Like, the moment you are signing a store or an office headquarter, there's a lot of enthusiasm and I would say the client urges you to get the contract done. This is not important. This is not relevant. Don't bother me. Don't bill hours on this problem. Focus on this and that. Okay, and then you work for days and days. At the end, you get a nice draft with all these comments and side marks. And again, you remind your client, well, I have to remind you that still this lease does not contain a break clause. 5 years later, oh, we signed a contract without a break clause. There is no way out of this lease. And I've seen in-house lawyers running all the memos received by the law firm. How's it possible? We didn't detect this problem when we signed the lease 5 years ago. How did that happen? I really I didn't develop a way to urge my client to find a solution, mainly because most landlords don't want any form of break or break option, break clause, exit clause, however you want to call them. In some situations, the law could help you. And we are talking about, recently, even in Czech law, but if you think of the doctrine of frustration in the common law system, in Italy it's called the excessive onerosity of a contract, and in Czech law it's fresh, it's in the new civil code, I can't remember the name right now. Under some circumstances, the court can cancel one specific term of the contract, but you have to file a lawsuit to get that. So, to complete the presentation here, these are the solutions clearly early termination clauses to those issues I've mentioned before. Shareholders' agreements. This is something Europeans don't do, and Americans do, and English people do. And I think we Europeans are still like learning why are they helpful. when you set up a company, you may have heard that you need to hire a notary, for example. In Europe, most of the time it's a notary, not necessarily in the States, not in England. And you have to sign, I mean, the founders have to sign a document called company constitution or articles of association. In Czech it's společenská smlouva. That document contains the fundamental rights and remedies. It is, legally speaking, it's a true contract. It describes who's going to be appointed as the first director, where is the company seat located, what are the shareholdings, who owns what, the boards, the powers of the board, the powers of the general meeting, liquidation, and so forth. The problem with the company constitution as they stand in Europe nowadays, it's a copy and paste of the statutes. I mean, what notaries do is pretty much, lawyers do, copy and paste the default provisions of Companies Act or civil codes. And I remember the moment we were advising this client over this 50-50 partnership problem. We opened the articles, we read it all, and there was zero to help us. Zero. No dispute resolution clause, no put call option, zero. In order to, I would say, in order to prevent these problems, it is a wise and good thing to get your business partners, even before you incorporate, to sign a shareholders agreement. Shareholders agreement is a contract between or among the shareholders of a company. It's a private contract. It needs not to be notarized. You speak about civil law, the civil law context. It binds only the shareholders, and it can pretty much contain everything which cannot be squeezed in the standard articles of association. So you can regulate the director's appointment, who is going to be appointed for the next 3 years, how to remove those directors, under which circumstances you may take action against those directors. You can create a sort of private company constitution which needs not to be filed with the commercial register or the other public filing systems. So it's a private document among the shareholders. It can also describe how you will exercise your voting rights. You can, well, your friend, your business friend will sign to a clause saying, well, in matters of finance, I will always vote yes or no. I'm oversimplifying here, but it is a document which goes much farther than the Articles of Association in setting out what are the rights, the powers, the competences of the single shareholders. And mainly, chiefly, exiting the company. When you design a venture, when you think of your future, your company's future, there's always a moment, and it's unfortunately it's the role of the lawyers to do that. What if this partnership, what if the shareholders will split in the future? Oh well, in that case we'll see, we'll deal with if and when it happens. However, by forgetting this problem, you may waive some of your important rights and some balances you have considered, you have implied in the beginning of the venture. And later on, your dear ex-friend or your dear business partner can take advantage of the fact that those initial agreements we had were not contained in any document. They were not in the articles. It was not in the articles that shareholder Marek was a poor guy, I helped. He never paid any contribution in the company. He never paid any share capital. I lent him the money to pay his shares. And how now he's creating troubles. I want him out. we look at the articles, it's 50-50% shareholding, there's nothing you can do. And the client is telling you, but he, yeah, remember that, look, well, he didn't pay his shares. I was like, oh, well, how is that possible that he didn't pay the shares? The 50, no, because, yes, formally he paid the shares, but I lent him the money to get those, to pay those shares. Oh, do you have a document evidencing that? No. Do you have witness? No. Very good. Oh, a shareholders agreement can describe the background of your business venture much more than the simple articles of association. If you're all Czechs, have you ever tried to deal with a notary here? He's basically going to tell you no to every proposal you have. We want our company constitution to reflect the fact that, no, you can't do that. No, because the law says A and the code says B and you can't get that into the articles. And so it becomes again copy and paste of the, now it's going to be the Zákon o obchodních korporacích. So before it used to be copy and paste of the commercial code, and now it's going to be a different format. Even when you think about maybe your dear friend, your business partner, your trusted friend, one day will want to exit the company. And how do we solve that situation? In the next few slides, I'll give you some legal solutions to the problem of exiting the company. Specifically, this is a potential problem or a legal risk you want to assess at the moment you start, you incorporate, not later, because later, well, the business, there's not going to be time to think of those issues. That's what like my experience is like. It's not about like the clients I have are all like, no, well actually yes, this is a problem, this could be a problem, but now we're too busy to deal with the running, the management of the company, blah blah blah. Drag along writes, imagine a company where shareholder A holds 35%, B 50%, and C 15%. So you have one shareholder with in control of half of the company. If one day, and B and C agree on pretty much everything, but one day B decides to sell his shares, C may say, well, I want those shares. I want to keep control of the company before you sell to somebody else, right? If there is a shareholders agreement with preemptive right, if B wants out, he first has to offer the shares to C. If C does not accept, well, in that case, he can sell to another shareholder or a third party. So you will basically bind B to go to C first. And the shareholders agreement can contain provisions saying how much or how the price of the shares will be determined. You can set yourself, or the shareholders can set the criteria. The economical, the business criteria, I have no idea because my background is not from business. EBITDA, all those beautiful indicators you have to evaluate shares. Tag-along are a device conceived to protect the minority shareholders. I've imagined here an Italian and Czech, it's an Italian-Czech joint venture. I've seen this personally. Well, it was not a beer factory, of course, whereby Honza is the majority owner. He knows how to make beer, and the Italian guy, who's the minority shareholder, has the know-how to sell. He's a good seller. How many business ventures companies started like this? One day Hansa decides, well, you know what, I found a very good buyer of my shares, and I think I would like to sell my shares. What happens to the Italian Francesco? Especially if we're talking about a large investor, it will be also in the interest of the investor to get his hands on the whole share capital of the company, just on the minority. But it's also in the interest, imagine yourself in the shoes of Francesco. Like, if Hansa goes, what can I do? I'm lost, like half of the business. Like, I don't have the skills to make the beer. This is a basic example, but you can imagine something more complex. In that case, if you include a tag-along right in the shareholders' agreement, if a third party comes to Hansa and offers him 1 million euros to buy his shares, Hansa cannot just accept, but he must include Francesco's shares in that offer. So Francesco can tag and say, hello, I'm here. I need to be included in this sale of shares, so that also Francesco profits from the deal. He's not left out. Is this clear? Tag along. The opposite of tag along are, I call them piggyback, because it's Aaron may know about this. These are in Europe, we don't even have the words to translate this. I've seen the Italian covendita. It's really difficult to find the proper words, because they look like simple devices, but they can become incredibly complex languages in the agreement. Here's the scenario, like a venture capitalist who believes in Tom's business, he believes in the potential. Tom owns 50%, and Brian is right, so the chairs manufacturer become the best, top selling in the market. And the global manufacturer says, well, this is a good target company for us, but we want full control. We want 100% of the shares. We're not going to deal with a minority shareholder here. What you have is a drag-along right, or piggyback, because it's actually the shareholder jumping on the shoulders of the other. In this situation, there is an obligation to procure the sale of the shares of the other shareholder. So you drag the other shareholders with you. Last thing is I think this is buy-sell or shotgun. Last example of shotgun, and this is a very tricky mechanism. It's also a way to solve the 50% partnership problem. So in case you really want to go for a 50-50% partnership, think of this, include this provision. If there is a company deadlock, no A or B has the power to solve that problem. Okay, this is a mistake. This is from the previous slides. Sorry. Sorry, I don't have the material here for this clause. So, to conclude the topic here, moving for hiring a lawyer or discussing these three items, if I go back to the initial slide. Three main issues is fundamental for every business. Manufacturing, service, finance, whatever. This is fundamental. If you don't think of these issues now, when you're setting your business, there will be simply no time to deal with that later. Obviously, you won't run into these problems if you have a one-member company, if it will be everything in your hand. But a moment can come when you be opening your company to more shareholders, to investors. So remember that what you will sign, you're all from the Czech context here, so whatever you will sign in front of the notary will not contain, will not describe the scenarios you will face in the future. It's not a comprehensive document. So it is up to you to think of that in the future, how to solve that problem. Do you have questions concerning this? You want to share your experience? Have you ever discussed the legal issues at this level with your, have you ever thought of these issues?
I will probably start a small company with my friend, and 50-50, and I'm a bit scared now.
You are considering a 50-50?
Oh, yeah, probably. So
mission.
Maybe after this, not.
Well, again, 50-50 is not necessarily bad if you can conceive a system whereby you solve the deadlock. Like if there is a dispute resolution mechanism, something in the shareholders' agreement to provide like a way to solve the dispute. Either you will be deciding or he will be deciding, or recourse to arbitration. Or there will be a mechanism, and this is what the shotgun clause is about, triggering the sales of share. Like you will put a price on his shares, and he will either accept or he can force you to sell your own shares. This is what the shotgun is basically about. I don't have the example here. What I think entrepreneurs should do is to think about what could possibly happen if things go wrong. And this approach will also help your lawyers to assist you, if you are realistic. It also depends on nationalities, I have to say. The Czechs are more cold than the Italians, so they are sometimes able to think of potential issues the Italians are unable to see, just because sometimes the Italians are victim of the enthusiasm of the situation, and they turn very emotional. And, oh yeah, we're going to solve this, or this is not an issue, we'll find a way, and blah blah blah. What else I have here on the slides? I believe I had the lease problem. No, first let's move to the limited companies. Nowadays, pretty much in every European jurisdiction, you have a possibility to form a company limited by shares. Make no confusion. Limited by share means that you're liable only for the unpaid value of the shares, not for the values of the shares itself. And I think that the main advantage is that the bankruptcy of the company does not become your personal bankruptcy. And also nowadays in most European jurisdictions it can be a single member company. So it can be fully owned and controlled by you. If you think of Europe, there is also a specific tax exemption for dividends. So if you set up a structure with company A controlled by company B in 2 different European countries, dividends may qualify for tax exemption. It used to be called the mother-daughter or the subsidiary rule. This is a rule which comes from the European Union, and it changes every 4 or 5 years. So I'm not a tax lawyer.
I'm sorry, do you know if this is also the case in the Czech Republic?
Yes, yes.
It is.
So I think now the qualifying shareholder, it used to be like mother-daughter because it would be a company fully owned. For example, an Italian company owns 100% of shares of a Czech company. If there were 3 or 4 qualifying criteria for how many years you have maintained the shareholding, a minimum, it turned into a minimum. Now I think it's 20%. It used to be 100% and then into 20%. And the dividends are not subject to what we call withholding tax. I'm not sure if you have something similar in the States.
Oh, yes.
The withholding tax.
So I could, if I had my own company, I could then turn it into an LLC and be the sole owner, the sole controller
Yes.
of the company.
Yes.
So is there any advantage to maintaining a sole proprietorship?
I don't think so.
Other than saving
So-
administrative hassle of traveling to offices? That's the only advantage.
Yes. The initial cost is the advantage here because it will cost you less to be
Sole proprietor.
sole proprietor than having a company.
Well, that's explicit cost on the front end, but sole proprietorship makes no sense. Really?
Personally, I think it makes no sense. Maybe some of you are already sole proprietorship. It's like živnostník, I think it gets translated into that. I'm a sole proprietor when it comes to legal translations. I still have a license to do that.
Right. A živnostenský list?
Živnostenský list, exactly. Exactly. I'm not sure about the tax regime in the Czech Republic for that, because most of my clients are corporations and they use the corporation income tax rate. But it used to be a very good rate for the živnostníky as well. Now I'm not
So
sure.
now I'm crossing the line into heckling you a little, but then if you mistranslate something and cost a company €1 million, they could sue you
They
and
could
go after
sue
your
me.
personal assets.
Yes, they will go to all my personal assets.
Okay.
I never thought if like my assets in Italy, I don't have any significant assets in Italy, but yes, they could reach also my assets in Italy thanks to a mechanism called European execution title. So a court decision awarding damages can be collected in another country of the European Union. So it's much easier than say 7-8 years ago, like thanks to the European Union. These are, as they stand now, the requirements to incorporate SFO here in the Czech Republic. This is a revolution in a way. The requirement was about 7,000 euros until 1 year ago, and now the share capital can be 1 Czech crown. It has to be minimum 1 Czech crown for each shareholder. You need to hire a notary to create the company constitution, which I repeat will not be a solution for all your future problems. And you need to find a generous landlord who will sign a document called assent to locate company seat, basically giving you a permit to use that address on the company name. Have you considered incorporating under the new regime? Because I've heard this is really moving young entrepreneurs to Czechia rather than other countries in Europe because of the capital requirement, which is really makes it much more accessible nowadays. It's still not as easy as in the States, I was told. You can incorporate the company through by fax, faxing your information somewhere in Delaware, get the company incorporated in 3 days. No, this is true. This is not true of the Czech Republic only. This is true of Italy, France, everywhere. It's the civil law system. It's much more formal and I would say bureaucratic in many respects. And yes, the shareholders must now physically go to the notary and sign. Under the old regime, you could grant a document, checks called power of attorney, to somebody else to sign the company constitution on your behalf. And nowadays it's not possible anymore. You need to either to go to the notary or to get a notarial power of attorney, which I will not discuss. I don't want to bother you with these legal technicalities. But if you have questions about the incorporation process, we do it every day in my firm, and that's basically what we're seeing now is what I see as a head of the Italian desk of the firm is a real emigration of businesses from Italy to the Czech Republic, Poland, and Bulgaria for some reasons. Mainly because of the tax regime, but also because incorporating and licensing a company in the Czech Republic is now much easier than in Italy, surprisingly. So this is peculiar for me because I studied East European studies in 2003. I went to Berlin, and some Italians were telling me, what are you going to do in that ex-communist corner of Europe, backward? 8 years later, Italian companies are moving here and asked me, how do we set up a company? Is it so easy, really? They are used to much more formalities than the Czechs. This was a big surprise. It's something I could have not anticipated when I was studying in Berlin. What else we have here? Oh yeah, the tax rate. I'm sure you're aware of that. This is, I mean, Italy is now over 40. As for the lease problem, now let's be realistic. Most landlords will not accept early termination clause, save for specific reasons. The premises become totally unfit, flood, earthquake, a total breakdown of systems, electricity, water. However, some landlords are willing to discuss in these days a fixed break clause, meaning that in some specific period of time, like once in a year or once every 3 years, you can early terminate by giving a 3 or 6 months notice, only on that specific time frame, not earlier, not later. This is different from a rolling break option, whereby the tenant, like you, the business, is able to terminate any time, given notice. Like anytime, the business is not going down, it's not going well, let's terminate, let's send the notice. 3 months, end of the game. Rolling break options something that few landlords, especially if you're discussing the lease with a corporate landlord, very difficult to obtain. These days it's much easier to discuss the fixed break. The third solution, I'm sorry, it's like hiring a lawyer who will imagine a creative litigation lawyer who will be able to use doctrines like frustration or impossibility to perform and try to get you out of the lease. However, you must be advised, even if you find a very talented and creative lawyer, you will be under a legal obligation to pay the rent until the legal dispute gets resolved. So it's not that the rent stops the moment you file the lawsuit, unless you get a relief by the court. Questions? Something you want to share from your thoughts or your experience you had? Possibly not. I'm sure you didn't have to deal with the 50, 60 pages long lease agreements. This is also something that clients are keen to leave to the lawyers. Honestly, the big once I negotiated a lease which was as thick as a book, physically had to be bound like with a machine. That was outside Prague, by the way. Good. So if you, I don't know if you have other inputs or ideas for the. If you prefer, I will be. What was it? I'll stay here for the next 20 minutes. So if you have questions, you can approach me individually. Okay. So. Thank you for your attention.
Thank you. Perhaps a word on intellectual property.
Intellectual property. I'm not an IP lawyer, but the typical mistake most young entrepreneurs do is not to sign a non-disclosure agreement. So they have a beautiful idea, and they share this idea with their best friends. And one of the best friends betrays them, typically at the moment. The legal solution to that is a document called non-disclosure agreement. In Czech, it gets translated in dohoda o mlčenlivost. In this document, you take the pain of describing in details your business idea. What is it about? And it has to be in detail, something that a court can enforce and distinguish from other ideas. And you basically put a penalty against the investor or the business angel you're dealing with. If you will make use of this information other than A, B, C, you'll be subject to a penalty of 1 million Czech crowns. I'm just imagining here. Or you will be anyway, you will be liable to damages. You, the investor, you, the business angel, you, the venture capitalist. That's also something we Europeans haven't really learned very well so far. But I've seen this agreements circulating in Prague already a couple of times, and it surprised me how much they basically copy and paste the American or English models and try to find Czech words for those American legal notions. Yeah, or also non-circumvention agreements for, but that's more for suppliers, traders, trading companies. Like I sell Italian groceries to you, and you sell to the restaurant. So, yeah, the restaurant cannot circumvent you and get the groceries from me. That's the way.
Okay.
May I ask
Sure.
similar questions? Let's say you are a research company and some client have some problem. You have a solution for it, you research something, you sell it to him, but there comes another client and which has very similar problem, and the solution you used for the first client would be the same. Can you do this or not? Because of course you have some disclosure agreement with the first client, because let's say it's very good know-how or some high-tech solution. Can you sell the same solution if other client has the same problem or not?
Very difficult to answer. Well, what kind of research are we talking about, if I can ask?
Well, we are talking about some thin layers or some materials.
Okay, so it's about products.
It's about the products, and it's used in, for example, automotive industry, for example, or industry like this. And yeah.
So you research and you develop a solution for one specific client. You talk with the client to get the solution work the best for him.
Exactly.
There is a dialogue going on maybe for months and years. Another client comes and it's the same problem.
Yeah. Well, for example, now is a new legislative reach which says that there should not be used chromium in some alloys of steels and like that. So many companies like Airbus and Rolls-Royce and like that are solving the same issue. Like this, how to make something without the chromium, which is used very regularly. So client A goes here, okay, let's say we have solution, and half year later, the new client, which is exactly the same problem, comes. Can we use the solution or not? Or how is that?
There's an easy solution to that, getting the first client's consent. Getting the authorization of the first client. However, the client is likely to make questions. Who is the other client you have? Give me more background. And the other solution is to hire a very intelligent lawyer who is perhaps changing the document in a way that what you're selling to the other client looks or is slightly different from you sold from client. But you need a system to do that. It cannot be improvised. And I believe only a very experienced in-house lawyer can do that, not necessarily me or an external counsel.
Okay. But in reality, you can't sell the same thing, exactly the same thing to two different clients if you say that it's.
Well, you can, as long as they pay the price. It could be a breach of the agreements with the initial client. It really very much depends on what language you have in the contract between your company and the first client. Also, what was the request, the client's request, the specific request he made. But legally, you can play. The problem is what kind of liabilities are triggered by that.
Sure. Okay, thank you.
You're welcome. Thank you.
All right.